Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
This lecture is going to cover key aspects of the UCC Uniform Commercial Code, Article 2, with regard to sales and leases. We're going to look at an overview and the scope and application of Article 2, talk about contract formation under Article 2, and there's a modification that comes with this on the mirror image rule, and the legal question of good faith and unconscionability in sales contracts, and the writing requirements. Yes, once again, we're going to get to the statute of frauds, and we're going to look at that with a lens from the Article 2 provisions. And then we're going to look at Article 2A regarding leases and related provisions, and take a look at some of the practical applications of what the paraprofessional might be doing in a position where they're dealing with Uniform Commercial Code matters, Article 2. So I went a little fast. Anyway, we'll start with an overview of the UCC Article 2. So we're going to deal with the Uniform Commercial Code specifically in sales, and which is Article 2 of the UCC. And first of all, with respect to the UCC, again, this is the law that has been adopted in all 50 states, in whole or in part, to govern essentially what are considered commercial transactions. Louisiana adopted portions of the UCC beginning January 1990, and that was primarily to modernize its commercial filing and secured transaction system. It was the last state to adopt the UCC, and even today, it has not adopted the entire code. The Uniform Commercial Code is oops, I've gotten a little too far. Sorry. Okay. The Uniform Commercial Code is organized into numbered articles, each governing a different area of commercial transactions, from sales to checks, bank checks, to secured loans. Think of it as a set of coordinated rule books that together create a unified system for modern commerce. And the structure is intentionally modular so that states can adopt articles individually and courts can interpret each area consistently. The UCC covers transactions between merchants as opposed to a merchant and the consumer. For example, some of the parties to the contract both of the parties to the contract have to be merchants. And that means they regularly deal in those types of sales, that particular type of business. And it also has to be a sale for goods and not as a contract for services. So we're talking about a sale of goods between merchants. So those contracts are going to be governed by the Uniform Commercial Code, which is a pretty significant document in and of itself. As I mentioned earlier, some states have adopted all of it, and some states have adopted part of it, with Louisiana being the long-time holdout on it. But they finally did, and they did black out Article 2. So what is the scope of Article 2 of the UCC? First of all, it deals with both the present and future sale of goods. So a current transaction and then transactions that will take place in the future are involved. The concept of a sale, when you sell something, you're essentially passing title, which means ownership of those items or goods for usually a price. And so goods are things that are movable at the time of identification to the contract. So these are things that can be transported or somehow moved from one location to another. Now, like I said, the UCC only governs contracts between merchants for the sale of goods, not services. However, sometimes you may have a... Sorry for the dog. It's that time of day where that can happen. So, like I said, the UCC only covers contracts between merchants for the sale of goods, not services. However, sometimes you may have a contract, for example, that may contain both goods and services, and that would be an example of a hybrid contract. So let's say, for example, that you have a contract where a company is selling printers, copy machines, copiers, whatever they're called now. I guess you can call them another company or whatever, and they're selling them. They called another company and listed them, and they're selling them 100 copiers to be used at their different locations. And as part of the contract for the sale of those copy machines, it includes installing them and making sure they're functioning for, let's say, the first 30 days that the copiers are going to be delivered. So the main purpose of that contract is the sale of the copiers. There is some service involved, so the installation part of it and dealing with issues in the first 30 days, that is a service. But that's not the primary purpose of the contract, so in a contract like that, Article 2 would still apply because the primary purpose of it is the sale and not the services. Now, if this was a contract, for example, between two companies, with one providing service to existing copiers for a length of time, that obviously strictly deals with service. So that would not be one that would fall under Article 2. So in contract formation, there's a departure from common law in the areas of offer and acceptance, and we're going to look at those next. Now with common law, excuse me, we learned about under common law what we need to form a contract. So we need to offer, we need consideration, offer, acceptance, and consideration. Those are the three initial ones. There needs to be a meeting of the minds. It needs to be for legal purposes, and the parties have to have capacity to enter into the contract. The benefit of the UCC is that it makes things a little more flexible for merchants so that contracts don't fail because they're missing minor things that would cause them to fail if they were, subject to common law. So first of all, with respect to offer and acceptance, the offer, any manner that it's done in, as long as it's sufficient to show that the parties agreed that would be sufficient. There are some terms that can be left open, and now you remember under common law, the terms have to be very specific. If you don't have all the specifics as to the contract, what it's for, time of delivery, price, things like that, all those different things, then the contract will fail for not having a proper offer. Well, you can leave some of those terms open under the UCC and still be fine. And generally, it will just fill them in. And they'll fill them in with what's acceptable in that particular industry. So if acceptable routine delivery of goods in a particular industry is a 2-week time period, it would imply 2 weeks. It may also be hard to determine exactly when the contract is formed, and firm offers of a company when a company makes a firm offer to another one, and that can stay open even if there's not any consideration and you accept shipment of the goods. And that's just enough to be an acceptance in form of a contract. So modification of the mirror image rule also comes into play with the UCC. There are additional terms under the UCC and compared to common law, and there's some missing and open terms that are explained by behavior of the parties. Now, the mirror image rule, you might remember from earlier lectures, hopefully you remember this about common law. It said, essentially, if you typed up or wrote out the terms of the offer, and then on another piece of paper you wrote out the terms of the acceptance, and you held either one up to the other, they would be alike. They would match each other. It would be like holding it up to a mirror because the terms would be identical. The same particular goods, same amount of goods, same date of service, everything would be exactly the same thing, including the price. All of this, everything was identical. So it was like a mirror image. That's where the name comes from. Well, again, we have a little more flexibility under the UCC. Under the UCC, additional or different terms are just considered additional proposals to the contract. And under common law, if you came back with some different terms, that would generally be a rejection or a counteroffer. And one of the exceptions to this under the UCC is the unconditional, additional consistent terms become part of the offer. So that's something to consider. What we mean by that is certainly if there are any additional or different terms that will materially alter the contract, then there will be no contract formed. And finally, under that exception, one party can condition its acceptance based on the other party accepting some additional or different terms. But the unconditional, the additions will constitute an acceptance. All right, if you have any missing or open terms, the parties' behaviors can show that there is still a contract under the UCC if they behave as if there is a contract. Another nice thing about it is that the merchants, if they leave out things like price, delivery, method of payment, whether that be check, credit card, what have you, those can actually be omitted, and the UCC will fill in the terms with what is reasonably used in those circumstances. So that's pretty significant in terms of allowing it to still be a contract. The idea behind this is that, again, you're talking about a merchant. So you're talking about people working for businesses that regularly deal in the sale of these particular goods, whatever they happen to be. So they're held to a higher standard than the average person entering into a contract. And they're assumed to be, for example, if they don't put in whether it's a check or credit card, and then it's not going to fail because of that. UCC also includes duty of good faith and unconscionability in sales contracts. And we're going to look at the procedural and substantive aspects right now. Now, there's a duty of good faith that's implied under common law, and we didn't talk about it, with the exception of talking more about if there's issues with fraud and things like that. But with any contract under common law, it's implied that the parties are acting in good faith as to what they're stating in terms of their products or services or what have you. But under the UCC, there is an explicit requirement of good faith, meaning the parties have to be behaving and stating things that are only true. Honesty, the word honesty, in fact, is how they refer to it in the code. Since we're talking about merchants with the UCC, they also consider this concept of commercial reasonableness in terms of what is reasonable in a commercial setting with entering into this contract. Now let's look at the concept of unconscionability, which is a bit of a tongue twister of a word. Unconscionable means something that shocks the conscience, something that is just shocking, and something that you couldn't conceive of doing. You couldn't conceive of doing that would be okay. So unconscionability in sales contracts is what generally happens is you have a merchant and a non-merchant. So you have a merchant who's selling to a non-merchant, and generally speaking, the merchant is going to be drafting the contract. Usually has more say in it. They also usually are in more of a position of power over the non-merchant buyer. So when we're talking about this, we're looking at two different things. the court's going to look at, was there any lack of meaningful choice in terms of what the buyer could do in terms of the contract? Was it a take it or leave it situation with the contract? And did they have any say whatsoever in choosing the terms or specifics of it? A lot of times they don't. Substantively, the court would look at the terms in a particularly biased way in favor of one party, usually the drafting party, and they can be particularly harsh on the impact, being in a higher level position of having more knowledge. And if that's the case, then usually if a contract is found to be unconscionable, then it's not going to be a legal contract. But the non-merchant in that situation would also be entitled to damages, to be able to ask for damages from the court, whether liquidated damage or other types of damages. Next, we're going to look at the writing requirements. It seems like we get to cover the statute of frauds a lot. And as I pointed out in the introduction, we have statute of frauds. We've got to look at statute of frauds in relationship with the Uniform Commercial Code. This will also take further the discussion of parole evidence rule and admissible and extrinsic evidence. So the requirements of so as already noted, requirements for sales of goods over 500, the statute of frauds requires under Article 2 that sales over 500 for the sale of goods between merchants must be evidenced by a signed writing in order for that to be a valid contract. And the writing does not necessarily need to include price or quantity to satisfy the legal requirements, as is the essence of UCC. Statute of frauds is something we've talked about in common law, and we went over the various types of contracts that have to be in writing in order to be valid. And the UCC is similar in that it does have certain circumstances where a contract must be in writing, as I pointed out, the $500 sales. And in that case, the merchant under the UCC has to object in writing within 10 days or a contract will be found to exist. So if they don't get that objection in writing to the other party on a timely basis, the contract will be held to exist. Now, there are certain circumstances where writing is not required. If there are specially manufactured goods, if it's one party admits in court that an oral contract did exist, or if the goods were delivered, accepted, and paid for, even though it wasn't in writing, there is still a good contract, despite the fact that it should have been in writing under the statute of frauds. So if it's something specially manufactured, for example, maybe something personalized, and it has printed on it, that type of thing is specific to the buyer. If the buyer later admits, yes, we had an oral contract, they agree they had a contract, even though it wasn't in writing. And certainly, if the goods were delivered and accepted or paid for, delivered and accepted or paid for and accepted, either way, you acted as if there was a contract. You took the goods and you paid for them, or you're the one selling the goods and you delivered them, and they were accepted. Then the contract will be deemed to have existed in those circumstances. Now we're going to move on to the parole evidence rule. You should remember from before, the parole evidence rule is basically stated that once there is a contract and it's reduced to writing, that the court is not going to allow in evidence, that explains, clarifies, or supplements the terms that are put down in writing. Under the UCC, however, things are a little bit different. The court may allow, with respect to determining what the terms of the contract are, the language in a contract, and that means if there was another document that the parties had, and sometimes this would be maybe emailing back and forth or letters back and forth or contemporaneously with the contract that have to do with what the party's understanding of what the contract actually means is, they can look at the court can. Another thing that the court will look at is they'll look at the prior conduct with these two parties toward one another. How did they conduct business? How did they work on their contracts before? Was it what they do? If, what did they do if they had consistently in so many that they had done consistently in many prior contracts? So they might, look to that and essentially see what their intent had been before, how they had dealt with each other before this course of dealing. Their prior actions and conduct will determine whether or not the contract exists. Another thing that has happened will happen, or that's common in different trades. There can be language or jargon, if you will, maybe a better term that's used in that industry and only in that industry. So it means certain things that, and it may in common language mean something totally different. And that's certainly common in different industries for them to have specific terms that mean something to them, and only people in that particular industry can fluently speak their language and separate this from ordinary language, ordinary terms. And unless they're familiar with it and work in that industry, they can't do that so easily. So the court will look at what are commonly accepted industry standards and practices in terms of a contract and deciphering what the parties' obligations are under it. They'll also look at the repeated acts of performance by the parties to the contract in the past and how they behaved. And so the question would be, what is the sequence? They might ask is, what is the sequence of conduct between them on that particular repeated occasion for performance? So again, they're going to look at what the past looked like, and in all likelihood find out what you intended to do is proven by that information. If you always did the same thing the same way, then chances are you were intending to do that way as well. Next, we move on to Article 2A regarding leases and some related provisions with respect to leases. So leasing is where you have one party that owns property, whether it's equipment or real property or anything like that. But thinking about in terms of related to equipment, say you have a company that owns bulldozers and they lease those out to construction companies and other people for use. Under Article 2A, UCC does deal with leases, and that's something that's been common for people to, people because a lot of people can't afford necessarily to buy a bulldozer when they're only going to need it maybe 6 times a year. So it makes more sense to lease it or rent it at the time that they need it. 2A, by the way, is the one article in Louisiana that for whatever reason has not been adopted from the UCC. So that's important to know. So a lease is defined as transferring the right to possession and use of goods for the term, for a period of time, a term, in return for consideration. A more common way to me to put it is allowing someone else to use your property for a period of time in exchange for you paying money for it. So the question is, what is a true lease versus other types of situations? So this is a little bit complicated in trying to understand, because Article 2 is going to apply to what are considered true leases, as well as consumer leases and finance leases. With respect to security agreements, that is something that falls under Article 9 of the UCC, and essentially a transaction that's called a lease would be considered a security interest if certain things occur. And basically it's generally when there's really no end to it in terms of time, and the lessee can continue renewing the lease for as long as a particular equipment or goods or whatever they're leasing exists. They can actually sometimes, like if you hear of a rent-to-own situation, you could actually become the owner of it. If you're talking about that kind of lease situation, that's a security agreement, and different article applies to that. Again, it's kind of complicated and not something you really need to focus on, but just be kind of vaguely familiar with it. Again, I'm sorry, my dog is terrible this time of day. I don't know why I decided to do just one more video. So I'm looking for a shotgun mic that's affordable so that maybe get rid of some of that noise. Okay, so practical applications. We'll put up with a little Smoky for a minute more because we're almost finished. 2 slides left. We're going to look at some practical applications of the legal professional, the paraprofessional specifically. From the practical application standpoint, the types of things that'll pop up under Article 2 of the UCC that a paraprofessional might be involved with include something called the bill of sale. And it's essentially a document where it includes the information as to the seller and the buyer, the date, the amount to be paid, and the description of the goods that are going to be sold. So it sets out those terms. It's a really simple document. A general contract for the sale of goods is going to be a little longer, go into more detail, and there might be some sections on warranties and packaging and inspections and remedies and things like that. Also, an offer to lease personal property, and this could be, for example, like leasing a computer, equipment, copiers, printers, things like that. That's another example of a lease that would fall under Article 2 of the Uniform Commercial Code, and personal property would be tangible property, not real property like land and things. A lease renewal notice is essentially just another document that paraprofessionals are often tasked to be responsible for. It's basically a renewing document for a lease, for an existing lease. So in conclusion, UCC Article 2 and 2A, they'll provide a comprehensive framework governing sales and leases of goods. And they modernize contract formation, it emphasizes good faith, addresses practical concerns like writing of requirements and unconscionability, and mastery of these principles will support a fair and efficient commercial dealings. And they'll benefit both merchants and consumers alike. So thank you very much.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.